Welcome to All Things Financial with Jack Driscoll.
Welcome back again, everyone, to another edition of All Things Financial. Today we have a return guest, Colin Morgan from Julian Associates. Thanks for coming back, Colin.
Thanks for having me.
What we're doing is getting into a discussion on the legal affairs, especially pertaining to retirement and senior living. So what I wanted to do is invite Colin back to talk a little bit about people who are considering getting near the age of retirement, how to make sure all their plans and legal affairs are in order. So, Colin, what type of situations are you running into when you talk to the 50-year-olds, let's say, or the 60-year-olds who really don't have any specific needs? They're just coming and asking you, what all do we need to start thinking about?
Absolutely. So when an individual is retired, or family has retired, and they're living that retirement life, they're traveling between their kids' families and being babysitters and all that stuff. All my clients say that they're more busy now that they're retired than when they were working. Well, other considerations come up in those situations. Sometimes there is a family history of a certain disease or disorder. Sometimes people have Alzheimer's in the family. They can be more susceptible to strokes, things like that. That while there's no diagnosis currently, while there's no threat currently, the writing's on the wall that something might happen.
You mean because maybe it's in the genetics from they've seen it in their parents or grandparents?
Exactly. So some diseases are somewhat hereditary, Parkinson's, dementia-related illnesses. And what those mean to a lot of families is that they have to have some planning considerations. Most likely, if somebody has that diagnosis, you're going to have some modicum of medical care, expensive medical care that's needed and necessary in the future. So my more conservative-minded fiscal clients come to me and say, how can I plan for this? Because I could do the best estate plan in the world, and I can have an airtight will and a great revocable living trust, but if that person or that individual goes into a skilled nursing home and I haven't planned well enough, well, there's no estate to administer. At the end of it. So to avoid that, we look at what I would call a more elevated plan. This is a pre-plan for medical expenses. We're looking at eventual, I think we'll talk about this in the future, but medical assistance and Veterans Affairs benefits, if that's a possibility, as well as a little bit more in your world, things like long-term care insurance, and touching up the life insurance and making sure that maybe they're not 100% in the market anymore, things like that. You really need to address a lot of different things. So what I suggest for these clients is that they enter into a more protective style of trust. Maybe through their 30s and 40s, they've accumulated resources, and we did a revocable living trust to make sure that assets pass properly upon their death if it happens, at a younger age. But what we want to look at is to use qualified trusts, meaning that whatever asset you place into the trust is no longer countable for a means-based benefits program. And that's really important.
We would look at that early?
Yes, I think as the earlier the better.
Okay.
Because a lot of these means-based benefits program, if you do this planning, there's kind of a cooling off period or a look-back period, which means that for things like medical assistance, you have to wait 5 years, to get any assets cleared into a trust.
Okay.
As of right now, there's no look-back period for the VA, for Veterans Affairs benefits. However, they're looking to impose a 3-year look-back period as soon as possible. So getting in ahead of all that stuff means the earlier you plan, the less issues you'll have. Now, these trusts are restrictive, and we'll talk more about the specific benefits programs later, but for example, a trust that will get you qualified for medical assistance and or VA benefits means that anything you put into the trust, you have no direct access to it anymore. So your clients who are 50 and 60 and they're still running their own day-to-day business and they want to have control over their resources, we want to pick and choose what makes sense to put into the trust. And my advice for clients are the family home and the life insurance policies are the easiest things to put into a restrictive trust. You never draw on the principal of a house, right? You only live in it. Generally, you never draw on a life insurance policy. You can take loans against them, but that's not drawing out cash value. That's just loaning against them. So it works. Those two products work very well in one of our trusts. Also, a lot of our trusts that are more restrictive still allow for income to come out to the trust to the original person who funded it. Okay. So if you're looking at products like fixed index annuities or dividend producing stock, things like that that actually pay an income, that works great too. So anything that your client isn't considering spending down, they're walking around money or their vacation money or that kind of stuff, good thing to put long-term investments.
So their assets they're trying to protect.
Yes.
And extend to the next generation and protect from being lost to a nursing home.
Exactly.
But they're in their 50s and 60s and aren't even having any consideration that it actually might even happen to them.
Correct.
So what happens when they go into these trusts and it turns out nothing actually happens to them, or later they change their mind? Is there what do we do here?
Right. So these trusts are also great estate planning trusts as well. They work the same way as the revocable living trust, where they avoid probate. They are tax-friendly trusts. So, these aren't a one-trick pony deal. You don't put it in and it qualifies you for the benefits program, and if you never use it, you just made a bad investment. That's not the case at all. So you get all those benefits of estate planning. But also, if they decide that they want to back out of one of these trusts, it's possible under the Uniform Trust Code, which is not to get into the specifics or the minutia of the actual written law, but what it allows for is even in an irrevocable trust, which a lot of these trusts are irrevocable, if all of the grantors, meaning the people who set up the trust, and all of the beneficiaries sign off on the change on the trust, you can revoke, amend, or alter any of these trusts. Okay. So I always tell my clients when they ask that question, I go, well, I'm going to sound like a complete lawyer here, and I'm going to tell you that this is an irrevocable trust unless it's not. So there are ways to get out of it.
That's good to know.
Yeah, absolutely. Yeah. So it's not as restrictive as somebody might think.
Okay, yeah, because it sounds a little scary.
Oh, yeah. Hey, when you tell somebody, well, I'd like to put you in an irrevocable income-only trust, they go, oh, my gosh, that sounds serious, you know. And, it's serious. It's very good planning. But there are always ways to make sure that the trust plan is catered to the family. The best case scenario, or the way you want it to happen, is that you set up the trust, and it is restrictive, but it works properly, and you only put the resources in that those people are comfortable putting in.
Okay.
So, if you have a family who, kind of a typical family, they have their IRA, they have their house, they have their life insurance, and they have various CDs, mutual funds, things like that. You put the house in and you put the life insurance in for your young, healthy clients. You don't put anything else in. So if they want to play with their mutual funds and take money out and put money in and all that stuff, or if they have a big, cash fund, in a money market account, or so, leave that go until you get a diagnosis, or until they really start to age.
Okay. What are the fundamental considerations that you'd have for all of these families when they're getting to that stage? What about, do we worry about still their parents might be living, or that they're inheriting assets, or their kids and maybe now even grandkids? Do we have to worry about that multi-generational type of planning?
Absolutely. And oftentimes when I meet with a family, I either work up to the next generation afterward, or I work down to the generation preceding after.
Okay.
In my more, crisis style of planning that we'll talk about later, oftentimes the kids come to me and they say, okay, how do I make sure that doesn't happen to me and my family? But for the children, in our questionnaires to our clients, we ask, how are your parents? Is anybody sick? Does anybody need help? Does anybody have, medical concerns? And if we see that, we're not here to upsell, we're not refrigerator salesmen or something like that, but we say, hey, we'll do all of your pre-planning for you, but we might want to look at mom and dad.
Yeah.
Now, what you also see, and what I see a lot, and it's an area of planning I'm very honored to help with, are individuals who have young children with disabilities. So when you talk about grandkids and things like that, Pennsylvania has wonderful, wonderful programs for children with disabilities. Medical programs, occupational therapy, employment programs, activities, things like that. They're all means based. So
what does means-based mean?
Means-based, good question. Means-based means that you can only have a certain amount of money in your name to qualify for the benefits program. Normally around $2,400. So it's a really, really tight ceiling, to work with. So maybe grandma and grandpa are very concerned about their young grandchild who may be autistic or may have Downs or something like that.
Okay.
And they say, well, we want to make sure that he's very well taken care of. So we're going to leave him $100,000 in cash. It's a great sentiment, and it's a really, I can appreciate that altruism. But if that young man turns 22 or something and then receives $100,000, he's going to get knocked off of every one of his benefits programs.
Okay.
So what we do is we set up trusts to serve as kind of catcher's mitts for those people. And this is not even just people who are who may be disabled. This is individuals who might not be great with money. That's another thing. And we call these supplemental needs trusts. So this means that, I'm not getting the inheritance directly, but a trust that's set up only for my benefit is going to get, the inheritance.
Now, talk about that a little more, this disability planning. I don't hear a lot about that.
Not a lot of people think about it, and not a lot of people think about it from a lot of facets. There are a lot of things that you need to make sure happen right, okay, when you're the parent of an individual with disabilities. So, and these parents are very savvy toward these programs. They weren't when they started, but as soon as you're into it and as soon as you're working with it, you learn so much. I have individuals in my family who are just incredible, at navigating these systems for their kids, because there are things. It's not even so much of a money issue. Oftentimes, there's no access to some of these programs unless you're on the benefits. Okay. So, they're very savvy for it, but there's not a lot of playing. Well, what happens, when my son turns 21, which is typically when even an individual with disabilities, oftentimes a guardian has to be appointed at that point. A lot of parents think, well, it's my kid.
Yeah.
Of course I'm going to be the guardian. And yes, with proper planning, that's exactly what's going on. There's nobody more appropriate than the parent. However, things have to be taken care of properly. So we do a lot of that planning with people. We go, okay, you need to call us, when
You mean that might not happen?
That might not happen. I've seen, kind of horror stories where parents are at least, temporarily blocked from helping make medical decisions, helping, work with banks and things like that, because everybody has a legal department. I mean, us lawyers, we really confuse everything. Okay, that's the old joke. If you ask a lawyer 2 questions, you're going to get 3 different opinions. So the problem with that is that a lot of these institutions, especially financial institutions, need to see papers to make sure that they're working with the right person. Because who has the deep pockets in this case? Who's going to get sued if something goes wrong? So most of the young men and women that I work with who are the age of majority and are disabled, they have the ability to execute legal documents. A lot of folks think that if you have a certain diagnosis that you're precluded from doing your own planning, and that's just not the case. So the best case scenario, the best work we can do for those families is to get powers of attorney, what I talked about last week. Okay, the financial and the medical powers of attorney set up for those individuals. So, if somebody goes to the hospital, the doctors aren't going to say, well, where's the power of attorney? We need to appoint somebody. They can say, okay, mom and dad are in charge here, so we're going to work directly with them.
Okay, that's good. What else on this disability planning? What are some of these considerations? And I'm sure sometimes we look at situations where we don't think the diagnosis is really a disability, but you would say there's specialized planning and there are programs available. Talk a little more about that if you don't mind.
And I totally agree with you. And one of the things that, as advocates, we really try to kind of, drive home with people who aren't necessarily working directly with these families is that, the term disability means one thing, okay, from a dictionary definition, but it's not exactly what you would think it is. A lot of the families with disabled children that I work with, I mean, these people lead, more interesting, lives than I do. Okay, they have wonderful jobs. They, go on vacations. They participate in wonderful things like the Special Olympics. They live independently, and they're really an inspiration. So, but you don't get there in a lot of these cases if you don't have, the proper resources for these families. Okay, so we look at things like waiver programs. Waiver programs are through medical assistance in Pennsylvania, so that means that it's again, one of these needs-based or means-based benefits programs.
Okay.
And this is what supplies things like, the daily therapies. This supplies to help people, occupational therapy is very important because this is what teaches a person how to live independently, which is what we all want.
Yeah.
And we all want for our family members and loved ones. So it also, shows occupational type skills. So this is where, you see people getting great jobs and leading full careers. I work with actually serve on the board for a wonderful organization called Southwinds Incorporated. They are an adult special needs not-for-profit that provides housing and care for individuals with disabilities. And so one of the things I learned and I thought was amazing is that a lot of these guys are retiring.
Wow.
Yeah, I love it. They have retirement parties from their jobs, and they get their Social Security, all that kind of stuff. Yeah. And I think it's just wonderful that this is available. Mm-hmm. But again, you have to do planning because if the family wasn't savvy enough, or if they didn't work with somebody who understood how to get people into, an organization like mine or Achieva or any of these companies that provide independent living for their loved ones, well, you never really get there. And if you don't get on the waiver programs, you don't get the therapies and the training necessary to live independently, and you don't get that, wonderful life experience that a lot of our folks get.
So if I hear you correctly, that leads toward, hey parents, hey grandparents, hey anybody who's named all your children or grandchildren equal beneficiaries on your 401ks or life insurance or annuities, you might be making a big problem for one of those beneficiaries,
Absolutely.
Right?
Absolutely.
What should they do? What should they be?
They need to name a trust as a beneficiary. So what happens, people who are savvy enough to understand that, if I name, my son on these programs as a beneficiary, that's going to get knocked off.
Because it's like, hey, grandson, I'm giving you a gift. Guess what? I just knocked you off all your benefits.
And you're writing a check to the state of Pennsylvania is what you're doing.
Wow.
Okay, if you do that. And so the next step, people who understand that, they say, well, I'll just leave it to my other child then. Mm-hmm. Okay, and he'll take care of his little brother.
Okay.
And most of the time, sure, that's what the intention is, and that's what you want to happen. Now, unfortunately, sometimes life happens. So if I have two kids, and one of my children is married with kids, and say he's a doctor or something like that, and the other child is this wonderful adult special needs child who has his job at Giant Eagle, is in his apartment, his high rise, does his own thing.
Right.
Well, if I leave $200,000 to my doctor's son to take care of my other son, and the doctor's son gets divorced, well, 50% of his assets are now subject to that divorce, including my other child's money that I wanted to be protected. Yeah. A trust can't get sued. A trust can't get divorced. A trust can't declare bankruptcy. All of these things allow me to set up a very strong, conservative, solid, stable situation for my clients' families.
Okay.
And that's peace of mind.
So we know right now, some of you families watching and listening are already making mistakes and have these situations with exposed beneficiaries who is detrimental. We know that.
Right, absolutely, and it's with the best of intentions. It's not anything where, some of these families I speak with, they go, oh my gosh, what did I do? And I go, you're okay. There's a solution, and you didn't do anything wrong. Let's just make sure that this works out properly. Exactly.
So it's outside of the area of just legal documents, though.
Absolutely. I mean the financial plan. Yeah. I mean, this is where your expertise comes in as well.
And the beneficiary designations and the 401ks and everywhere else.
Right. What you're doing, oftentimes, what people don't realize is that they are essentially setting up, something that's just going to destroy these benefits programs for their loved ones. They don't even realize it. And so even if I work and set up the legal framework, I set up a great supplemental needs trust and get everything together. If they don't, engage with a good financial planner or other professional who understands, well, hey, we need to change the beneficiary designations. I'll just have an empty trust, and then the money goes right past it to the individual and blows up his or her benefits. And there we go.
So you with Julian Gray Associates, elder law attorneys, but you're expanding far beyond that.
Absolutely.
Can you talk about that a little bit? What's happening in this world of estate planning and elder law planning and all that's expanding in your world and what you need people to know about?
Absolutely. So where we came from was elder law planning. These were, individuals going into nursing homes, and how do we save as much money? How do we stop the bleeding when you go into a nursing home? And our skill sets have gone into what we talked about last time, for younger individuals. We just have, high caliber expertise in planning documents. But what we've spread out into is planning for younger individuals with disabilities. A big area that we're planning now is sudden wealth management. Now, I mean, when I say that, I don't mean from a financial planning perspective, but oftentimes when somebody is catastrophically injured, and they sue, based upon that personal injury, they can receive this large settlement.
I see.
And if it's not planned for properly, it's just like that inheritance situation I was talking to. So, say you're, on waiver programs, you're, a 40-year-old guy, a construction worker who's catastrophically injured on the job, and you get all this wonderful care through the Commonwealth, and then somebody gives you $4 million. Well, first off, goodbye benefits.
Yeah.
And without proper planning, $4 million might seem like a lot of money, but 24-hour attendant care for a catastrophically injured person runs to the tune of $30,000 to $40,000 per month.
Ouch.
$4 million is not a lot of money in that situation. So helping plan to get somebody onto medical assistance and maintain those benefits, whether we have to spend down some money or whether we have to do some legal maneuvering to get them there, is extremely helpful and very vital to those clients. So that's another great area that we work in. So that's kind of that rebranding I was talking about. Maybe we're not just elder law attorneys now, and maybe elder law gave us the skill set to work with such a larger group of people.
Well, I still learn new things about Julian Gray Associates. All right, Colin Morgan's our guest for today. We're out of time. What I'd like to do is continue this discussion next week with some more specifically designed elder law care, nursing home care, planning for legalities before that happens, how to protect your assets, things like that.
Absolutely.
Is that okay?
Absolutely. Love to. Thank you.
Thanks for coming on the show. Hey, everyone, I appreciate your tuning in to another edition of All Things Financial. We'll be back again next week with some more discussion on really areas in senior care and how to make sure your assets don't get wiped out if something happens to you, specifically pertaining to nursing homes. We'll be back again next week.
Thank you.
Colin, can you help everyone listening and watching on how to get a hold of you?
Absolutely. So there are 3 great ways to get in touch with us. First off, you can visit our website. That's grayelderlaw.com. Secondly, you can email me directly. That's Colin, Colin, at grayelderlaw.com. Or you can give us a call at our front office. That's 412-458-6000. And what will happen at that point is you'll talk to our triage staff, who they're absolute experts. They know more than most people, more than a lot of attorneys about what we do. And they'll get a lot of good information for me, so I can start to formulate a plan proposal. And we'll have you in for a no-risk consultation. That means that if you decide that, not go with us, or if I decide that you don't need our services, then it's not going to cost you anything. So we think that creates a really good open relationship, with the firm right off the bat. So basically, those are 3 ways to get in touch. And if you need us, we're always around. So feel free to give a call or email. Thank you.
You've been listening to All Things Financial with your friend with the answers to all financial matters, Jack Driscoll of Driscoll Insurance and Financial Services. Securities and investment advisory services offered through Sage Point Financial Incorporated, a registered broker-dealer and registered investment advisor and member FINRA and SIPC. Driscoll Insurance and Financial Services is not affiliated with Sage Point Financial, Inc. or registered as a broker, dealer, or investment advisor. You can reach Driscoll Insurance and Financial Services Incorporated at 412-833-1500, and they are located at 2738 South Park Road, Bethel Park, Pennsylvania, 15102.